Hello. Welcome to the Worker Solidarity Network's Know Your Rights workshops under the Employment Standards Act. I invite you all to grab yourself a drink, get yourself comfortable, and show up to this workshop in a way that feels good for you all. You are welcome to pause this video at any time and take breaks, but we hope this will be helpful for you. Today's workshop agenda is we're going to go into introductions and who we are. We'll go into terms we will use, cover some Know Your Rights, and go over a summary. Some workshop guidelines. Today, you'll be working with Know Your Rights education at work and how to access them. We'll hold space for questions at the end, and I encourage you to write them down. This is a safe space, and all shared is confidential. And we will leave today with the tools to advocate for yourselves. I must note that this workshop is for educational purposes only. No part of this presentation should be taken as legal advice, and the staff at the Worker Solidarity Network are not lawyers. For legal advice, please contact a lawyer within your community. Now, first I'll introduce myself. My name is Pam Machado. My pronouns are she, her, and I've been with the Worker Solidarity Network for 6 years, and I'm happy to be sharing this Know Your Rights education with you today. A bit more about the WSN, Worker Solidarity Network for short. We advocate for the rights and interests of workers while taking collective action to improve labor standards for all. We do this through a few key pillars of our work. The first being distribute Know Your Rights education. The second is support and empower individuals with complaints and access to justice. And the last pillar is we campaign for long-term improvements for worker justice. Before we dive into the bulk of the Know Your Rights materials, I thought I would share some terms we will use and what they mean and their definition. That way, when I use these words throughout the workshop, there is a general sense of what they mean. The first one is wage theft. And for us at the WSN, that's when an employer breaks the law by failing to pay a worker's wages they earned and or are legally entitled to. Contravention is an act that breaks the law, and in this case, the Employment Standards Act. Examples are the employer contravened the Employment Standards Act by keeping tips for themselves. Another example would be the Employment Standards Branch found 4 contraventions in their investigation. Another term is the Employment Standards Act, for short, the ESA. Employment Standards Act is the law in BC that sets the minimum standards for conditions of employment like wages, breaks, termination, and more. And the Employment Standards Branch, ESB for short, receives, investigates, and recovers wages from complaints about contraventions of the Employment Standards Act. Retaliation, and what that means is the act of harming a person because they have done or said something, could be seen as revenge. Pay stubs. Pay stubs is a piece of paper or a digital copy that is given to an employee alongside payment of wages. It includes hours, taxes, and other wages or benefits. And lastly, entitlement. And what that means is a right to a benefit or protection specified by law. Throughout today's workshop, we'll review 7 important rights at work that are commonly asked about at the Worker Solidarity Network. And through those 7 different rights at work and how they are viewed in the Employment Standards Act, for each one, we'll go over how to take note and document and collect evidence for each of these seven rights that apply to you or may apply to you. And lastly, through those seven rights, we're also going to discuss how employers can violate or be in contravention of your rights and what that could look like. The seven important workers' rights that we'll be touching today and going more in depth shortly is getting paid for work, 2, unauthorized deductions, 3, tips and gratuities, 4, overtime, 5, statutory holiday pay, 6, compensation for length of service, 7, vacation pay. As I mentioned, we'll be talking about how to take documentation or collect evidence for all of those seven rights that you have at work. And it's important, one of the first steps to advocate for yourself is to take note and to write that shit down, like we like to say at the WSN. Things to take note or to keep are documents, and that could look like schedules, pay stubs, record of employment, for short, ROE, bank statements, employment agreements, and job descriptions. In addition, things to take note are approximations. So for instance, you could write your own records of hours worked, your own job duties, and your own job description, especially when they aren't similar to the job description you were provided, or in terms of record of hours, if your record of hours that your employer provides you is not the same record that you have for yourself or that you have worked. You could include how you made those approximations and include any documentations you have. And you could state roughly how accurate they are. And other things to take note of or to write down is correspondence. So you take screenshots of text messages, audio recordings of conversations, save or take photos of emails and notes that may show what happened or that something did not happen, and or witness statements. And the last avenue that we'll be going through all the Know Your Rights today is we'll be touching on how employers contravene your rights at work. And through this framework, it's important to know what to watch out for with an employer. It's important to know that it's never your fault if your employer is stealing your wages or contravenes your rights at work. We are all humans and make mistakes. Therefore, it's important that you know your rights at work in order to address those mistakes. And lastly, it's important to acknowledge that there is an inherent power imbalance between employers and workers. They determine so much of your life, including access to income. And it's important that you have the tools to advocate for yourself. Okay, now we're going to dive into the first, know your right, and that is getting paid for time worked. Some of the notes that are listed here is, and then it's important to know, is that you must be paid for all hours worked for an employer or a business. No work goes unpaid. You must be paid at least the minimum wage, which currently is $17.40. Or you could be paid at least the higher wage that's in your employment agreement. If you are expected to be available during your break, you must be paid for it. If you are placed at a place designated by your employer and you are performing labor for them, this is considered to be at work and you must be paid for that time. And it's important to note that certain work, such as agricultural work, does not receive minimum wage entitlements. Now, how to take note and keep track of if you're getting paid for all your hours worked. Write down what your rate of pay is and write down if you got a wage increase. How many hours did you work? You could take a photo of your schedule to calculate if your wages are accurate and that you were paid for all the time worked. An example here is if you're paid $18 an hour and you worked 20 hours, that would be a total of $360. It's important to note that if your schedule differed from the hours you actually worked, you could take note how much did your employer pay you, and that would mean keeping track of your pay stubs or taking photos of your pay stubs. And another measure would be to write down in a notepad or on your phone when you started and ended your shift. When it comes to getting paid for all your time worked, watch out for employers who say they don't pay you for training shifts, meaning unpaid training shifts. You're not paid to start work early or work late. If the job posting and the job that you apply for is less than minimum wage. And lastly, an interview if they suggest less than the job posting, if they suggest less of a wage than what was provided in the job posting during the interview. The second important right for you to know is unauthorized deductions. And what this means is an employer must not directly or indirectly withhold, deduct, or require payment of all part of an employee's wage for any purpose, such as business costs. What this could look like is if your employer is making you pay for uniforms, if you are paying for uniform maintenance, if your employer is withholding money from your pay to cover customer theft. In the same way, withholding pay for broken dishes, glasses, and items. And similarly, if you are being charged for recruitment or hiring cost. These are some examples of what unauthorized deductions looks like. To keep track and to take note when unauthorized deductions take place, take note if you were charged for a uniform. Have you had to pay for any of the employer's cost? Did you pay for recruitment fees or hiring cost? Write down and keep record of how much you paid for all of those examples, the date you paid for it, and what was it for. For unauthorized deductions, watch out for employers who say, you break it, you buy it. They say, we charge uniforms at this establishment. If they mention that they withhold pay for poor work performances, and if you notice that they're taking money off paychecks for business cost, like dishes or customer theft. The third right I want to talk to you about is tips and gratuities. Tips are money paid to you by a customer instead of the employer. And that customer assumes it will go to you and not the business. And a tip pool and how that applies is employers can require employees to pool their tips and to share them amongst other employees who do not have access to tip payments, like cooks and dishwashers in restaurants. Other notes about tips and gratuities and what are your rights when it comes to tips and gratuities is that employers can't keep any tips for themselves unless they did similar work to the employees who received tips at that time. And employers cannot deduct anything from your tips or tip pool, whether cash, debit, or credit. And an employer may not charge an employee for costs such as dine and dash, theft, property damage, or any other business costs. And they shouldn't take that from your gratuities or your tips. That note there would be considered an authorized deduction, as we had just covered. Taking notes of your tips and gratuities is really important because it is self-regulated by yourself, the employee, at times. So it would be important to write down how your employer pools tips. It could be in percentages. You could keep a photo or a copy of your cash out sales at the end of your shift. You could write a note of the amount of tips you earned in a shift, including the date in a notepad. Something to take note is if your employer takes tips from you or requires a house tip out, meaning that it goes to the employer or for business cost. And take note of the percentage you receive in tips or percentage that you tip out as well to other employees. When it comes to tips and gratuities, watch out for employers who say no tips in training period. If they say food mistakes or broken dishes come from your tips. And if you notice your employer takes an amount of tips from you. Overtime pay is the fourth know you're right that we're going to cover today. How overtime applies is when you work more than 8 hours in one day, you must be paid at 1.5 times your regular rate of pay. Overtime also applies for when you work over 12 hours in a day, and that must be paid at double your regular rate of pay. And those two are considered daily overtime, but there's also weekly overtime. So when you work more than 40 hours in a week, you must be paid at 1.5 times your regular rate of pay. It's important to note that overtime does not apply to agriculture, civiculture, and specific types of caregiver work. It's important to take note of overtime matters because oftentimes you're scheduled to work a certain amount of time and you're not scheduled for overtime. You just work longer. So you could take note of what your overtime rate of pay is. Did you work overtime, even if it was unplanned or not in your schedule? Remember, time over 12 hours in one day is paid at double your regular rate of pay. And it might be also important to note if your employer has a policy against paying or working overtime. And it would be important to take a photo or have a copy of that policy. Examples on how to take note of your overtime is an example here would be you worked 10 hours and your rate of pay is $18 an hour. The first 8 hours is calculated at $18 an hour, which totals to $144. And there's the 2 additional hours over 8 hours should be calculated at 1.5. And you could see there, so 18 would be the 1, and 0.5 would be half of 18. So the total of your 1.5 times per hour would be $27 an hour, equals $54 an hour. So with that, for the first 8 hours, you'd be paid $144 at $18 an hour. And then for the other 2 hours, you'd be paid $27 an hour, totaling $54 an hour. And those together adds up to $198 owed for that 10-hour shift that you worked. When it comes to overtime, it's important to watch out for employers who say that you have to bank your overtimes and that you don't get paid time and a half, or as mentioned, 1.5 of your regular rate of pay. If your employer says they will only pay for overtime if it's approved, but if you've worked overtime, you must be paid at the rate that overtime states. If they say we won't pay overtime due to company policy, if they tell you that you're not entitled to overtime because you're a contractor or a manager, if you are a contractor or a manager, overtime may not apply to you. However, there is a chance that you may still be entitled to overtime, regardless if your employer says you're a contractor or a manager. So if your employer says any of these things, it means that you may be entitled to overtime pay. The fifth right that I want to share with you today is statutory holiday pay. You are entitled to statutory holiday pay if you have been employed for at least 30 calendar days and have worked or earned wages for 15 out of the 30 of the calendar days preceding the statutory holiday pay or the statutory holiday. Examples of statutory holiday is when there's a long weekend. So Family Day weekend, over the Christmas holidays, New Year's Day, July 1st, also known as Canada Day. Those will be considered statutory holidays. Whether or not you worked on that day, the employer must pay you an average day's pay for the holiday. So if you've met the conditions of working 15 out of the 30 days of the calendar preceding the statutory holiday, you will be entitled to an average day's pay, whether you work or not. If you work on a statutory holiday, then you also earn 1.5 times your regular wages for time worked for the entire day, for all of the hours that you worked. So with that, if you work on a statutory holiday, you would receive an average day's pay and 1.5 times your regular wages. If you don't work on a statutory holiday, you should be paid an average day's pay. And anytime you work over 12 hours on a statutory holiday, you must still be paid at double your regular rate. It's important to note that farm workers are not entitled to statutory holiday pay. When taking note for statutory holiday pay, keep record of the statutory holidays you've worked. Write down how many hours you worked. And write down if you also have been paid an average day's pay. For statutory holiday pay, watch out for employers who say part-time employees don't get statutory holiday pay. And if they say we can't afford to pay statutory holiday pay. If your employer says those two things, it is likely that your rights are being violated. And it doesn't matter if you're a part-time employee or a full-time employee, as long as you have worked 15 out of the 30 days preceding the statutory holiday, you are entitled to statutory holiday or an average day's pay. The sixth right that's important for you to know is compensation for length of service. And what this means is you earn these wages throughout your employment after 3 months of service. And this right applies to you if your employment is terminated under certain conditions. So if your employment is terminated by your employer without just cause, if it's without notice, equivalent to the same number of weeks of pay you earned. And if your employment is deemed terminated, and what this means, if there's been significant changes to your employment, like changes, scheduling, um, conditions that might relate to health and safety, and so forth. How does compensation for length of service work? For short, we'll call it CLOS. CLOS is provided by an employer through pay or working notice, depending on your length of employment. And CLOS's calculations include vacation pay and statutory holiday pay that you earn during the calculation period. 1 week of CLOS pay is calculated by averaging out the most recent 8 weeks that you worked your regular hours. It's important to note that construction workers are not entitled to CLOS. In the table at the bottom of the screen there, this is how you would know how much of CLOS you're entitled to in terms of notice or pay. So after 3 months, if you were fired without just cause or deemed terminated, you will be entitled to 1 week's pay or notice. Between a year and 2 years, you will be entitled to 2 weeks of pay or notice. 3 years, you will be entitled to 3 weeks of pay or notice. And 1 year is added after every single year you've worked. And under the Employment Standards Act, the maximum is 8 weeks. So if you've worked 8 years plus, you would still be only entitled to 8 weeks of CLOS if you were fired without just cause or deemed terminated. When it comes to your termination or compensation for length of service, it's important to take note of when you started working and what was the end date of your employment. You could take note or take copies of termination letters, copies of the last 4 pay stubs in order to calculate the amount of CLOS you are entitled to if you weren't given work and notice. An example here would be the last 4 paychecks totals up to $4,000. 4 paychecks is 8 weeks of work, typically. So you would do $4,000 divided in 8, referencing 8 weeks, and that is $500. So that would determine how much money you are entitled to for a week's pay. And you would multiply that 1 week of pay, average week of pay, by the amount of weeks you are entitled to. So for example, if you worked for 2 years, you would take the $500 times 2 weeks equals $1,000. And that would be the amount of CLOS you would be entitled to. When it comes to termination or compensation for length of service, it's important to watch out for employers who threaten to fire you or terminate your employment. When they tell you they have just cause to fire you, oftentimes they don't. And only provide vacation pay and not compensation for length of service. So at the end of your employment, if they provided you vacation pay, then you would still be entitled to compensation for length of service. They are 2 different things. Which leads me to discuss vacation pay, which is our last know your rights material that we're going to touch on today. Vacation pay applies and starts applying to you after 5 days of employment. An employer must give you 4% vacation pay on either every paycheck or collected on the side and given to you when you take vacation. And it's important to note that if you've worked longer than 5 years, that 4% increases to 6%. It's important to note as well that when you're calculating vacation pay, that bonuses, overtime, commissions, and severance meaning C loss, are included in calculating vacation pay. To calculate your vacation pay entitlement, add up everything you've earned in that year and multiply it by 4%, or if you're on a calculator, 0.04. If you worked more than 5 years, you would change that to 0.06. An example, so let's just say this worker earned $5,000 in an entire year, multiplied by 4% or 0.04, and that would add up to being $200 in vacation pay. So you will be able to see that vacation pay on your pay stub. And if your pay stub doesn't reflect the amount that you've calculated, then you probably weren't provided adequate vacation pay. When it comes to vacation pay, it's important to know that you're entitled to request time off from work. You are entitled to 2 weeks of vacation after your first year of employment and 3 weeks after working 5 years. Your employer must allow you to take your vacation at least 1 week at a time. And then how do employers pay vacation? The employer may pay your vacation pay on the following pay period or at the start of your vacation when taking a vacation. Or in a mutual agreement, your employer can add your vacation pay on each paycheck. It's important to take note when it comes to vacation pay that you review your pay stubs between the difference between vacation paid out and vacation accrued. And then you could also keep the correspondence that you had with the employer when you were requesting vacation. And if your employer hasn't paid you other wages, such as overtime or regular pay, this means that your vacation pay might be short. And the last watch out for employers who, regarding vacation pay, is when employers are paying vacation on each pay. This can only be done by mutual agreement. And if you notice your employer is deducting 4% off your pay rather than adding 4% on your pay. And another one would be if your employer just isn't paying you vacation at all. In summary, you must be paid for all of the time you worked, no matter what. Statutory holiday pay and overtime pay both have different rates of pay than your regular minimum wage. You should have at least 2 weeks of paid vacation paid at 4% of your annual earnings. If your employer terminates your employment after 3 months without just cause or notice, they must pay you compensation for length of service. If your employer significantly changes an important condition of employment and you quit, it's possible that your employer may still have to pay you C loss or compensation for length of service. And lastly, it's important to know that employers cannot sink below those requirements, even through a contract. They may not go below what are your rights under the Employment Standards Act. Now, how to access your rights. I'll talk about 3 different steps on accessing your rights if you find that your employer has contravened or violated your rights at work. Step 1 would be to advocate. Talk to your family, coworkers, chef, manager about your issue. With your documentation, approach your employer about your issue. And only do this step if it feels safe to do so, right? If it doesn't feel good, then you don't need to take that step. Another step would be through community. You could reach out to the Worker Solidarity Network. That's me. And we can answer your questions. And with your documentation, you could share your issues with us. And we could support you with your issue. That could be answering your questions. It could be helping you file a complaint. And it could be reaching out to your employer with you in solidarity to let them know that they violated your rights. And step three, if you haven't managed to be successful in step one or step two, step three would be to file a complaint. With your documentation, you could file a complaint on the ESB's website, the Employment Standards Branch. It's important to note that you have 6 months to file the complaint after the issue. And once you have filed your complaint, an investigator from the Employment Standards Branch will be in touch with you between 6 to 12 months, closer to 12 months. As we're talking about advocating for yourself and accessing your rights, and now you know what your rights are at work. Perhaps you already knew them, but we got into the meat of it. It's important to know that the ESA has protections against retaliations. So it's important to know that an employee not to be mistreated because of a complaint or investigation. So if you are still working at a place and you're advocating for yourself and you're filing a complaint, your employer can't terminate your employment, threaten you of termination, reduce your wages, intimidate you, coerce you, or do any other penalty of at your work. The intent of the employer is not necessary to prove retaliation. But if you have experienced retaliation when you've been advocating for yourself, you must be able to show that it was reasonable in the circumstances to make a connection between acting against the employer's interest and some negative consequences that you have. Some further resources. Well, we've talked about the Worker Solidarity Network. We are a resource available to you at any time. But when it comes to specific issues at work, when it comes to wage theft, the Employment Standards Branch can recover missing wages, tips, return unauthorized deductions, and costs incurred as a result of the contraventions. If you've experienced injury at work, WorkSafe BC, you could report an injury. This addresses health and safety issues, including refusing unsafe work, bullying and harassment, injuries and retaliation related to health and safety. And lastly, if you've experienced discrimination, the Human Rights Tribunal would be your resource. They cover issues of discrimination related to several protected grounds like race, gender, disability, place of origin, and more. Today, we have discussed your rights under the Employment Standards Act and the resource available to you if you've experienced any violations of the rights that I've talked about today will be under the wage theft resource at the Employment Standards Branch level. And you can reach out to the Worker Solidarity Network about that. But the two other resources, injury at work and discrimination, we have other workshops that touch on those two, how those rights apply to you at work. There are many ways you get involved with WSN. If you like this workshop today, please join the network, which is full of non-unionized, unionized, community allies who are advocating for justice for all workers. You can get involved and become a member, or you could do some outreach. Becoming a member is free. Have your friends become members. You could follow us on social media. We do a lot of postering and outreach and canvassing to make sure that all workers have access to know your rights materials. And we also host a training on how to do outreach if you're interested. You could reach out to Chris at workersolidarity.ca. If you liked this workshop or want to take action, and if there's an issue or matter that's important to you, we could organize an action or event together. We could host a workshop for your family, friends, or other coworkers. We invite you to attend as many WSN events you can. You could bring your friends. Um, and you could even arrange one of your own networks. And if that's an interest of you, you could email Ismail at workersolidarity.ca. Thank you so much. I hope this information was helpful to you. If you have any further questions, please reach out to info@workersolidarity.ca. You could follow us on social media to learn when our next workshops are or our next events. You could become a member to be in the loop on our newsletter. And if you need support, if you're facing contraventions at work, you could go to workersolidarity.ca/support, and a legal advocate will be in touch with you to answer any of your questions. Thank you. Take care.